Hello, this is Matt on the Moon Family Said Dan channel. Have a few topics to discuss with you in this latest room temperature jam. One of them I actually teased at the tail end of my very last video, and it has to do with an incredible reason. I had never come across this specific fact before, but it has to do with why, cryptocurrencies like XRP, even if you get a bad court ruling in theory, it's another reason, a powerful reason, that XRP ultimately will be allowed to exist in the United States because it's computer code. And you know what? As it turns out, and this is the big one here, as it turns out, computer code, including cryptography specifically, as it turns out, that is considered by law protected speech under the First Amendment. That's a big deal. And it dates back to a case that almost 30 years ago that I just wasn't familiar with. And I was just like, yeah, there you go. There's yet another reason this isn't going to go the way the SEC wants it to go. It just isn't. Then there's also this headline from the Crypto Basic. Top lawyer says he dislikes Coinbase for hurting XRP holders. I'll explain the rationale there. And I'm on the same page, by the way. And I also want to give you an update on some of the latest nonsense the SEC is engaging in and how they're attacking cryptocurrency exchanges, including Bittrex, which has now exited the United States. And the fact that the SEC, in a normal world, it would just be inexplicable the way that they're still going after him, having exited the United States market. But here they are. And I've got a comment also from attorney John Deaton on exactly what he thinks the strategy is, why they're doing this. So anyway, plenty to unpack. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so let's dig into this first piece. Attorney Morgan says he does not like Coinbase as he cannot forget about what the exchange did to XRP holders. In a tweet yesterday, Australian-based lawyer Bill Morgan said he dislikes exchange Coinbase for what it did to XRP holders. Attorney Morgan noted that while he entirely supports Coinbase's lawsuit against the SEC, he cannot forget what the exchange did to XRP holders. And so here's the tweet. It's on your screen right now. It reads as follows from Attorney Morgan. I do support Coinbase in its litigation with the SEC. I just don't like them or forget what they did. I'm not in the "we are all friends now" club. Yeah, and so that's basically my stance. When it comes to Coinbase, I still don't blame them actually for delisting XRP, that initial decision to do that. That's what I think most, obviously most exchanges did. That's what their legal counsel advised them would be most safe. Now, it's not it's not exactly a bold position to take. I mean, it's just hoping that you're getting cover, from a legal perspective if you do that. Although we now can see that obviously was not the case. So, a little bit of a misjudgment there if that's what you were thinking. Exchange executives here. So I don't blame them for that. I blame Coinbase for what they did to XRP holders, expecting their Flare tokens, which took an unreasonable amount of time to ultimately be given out, but also the Songbird token, which still hasn't been given out, and they're just pretending like they don't have XRP holders' Songbird tokens. And they're getting sued by a different XRP attorney, attorney Fred Rispoli. And so we'll keep tracking how that unfolds here. So I'm in the same way. They're not treating our community so well. They haven't been historically. But even so, the right thing to do, because it's in our best interest, is to ally where it makes sense and support them publicly where it makes sense. And in this case, supporting them in their fight against the SEC, that makes sense even for us as XRP holders. We have the same interest there. We just do. But I'm still pretty grossed out by some other Coinbase behavior. So I'm totally on the same page as Attorney Morgan on this. But it gets even more interesting. So check this out. Piece continues. According to Morgan, Coinbase dumped a pile of bleep on XRP holders by not distributing its Songbird airdrop to users. Another reason Attorney Morgan dislikes Coinbase is that the exchange decided to delist XRP and not relist the coin. Per Attorney Morgan, the decision is inconsistent with other crypto assets the SEC labeled securities that are still listed on Coinbase. And by the way, I'll just pause a note there. It is inconsistent. So now that's not a reason that I am extra fear. I mean, I can understand the frustration. So if you're feeling frustrated about that, you're not wrong. I get it. That's fine. That's totally fair. But I think that the reason that they delisted XRP in the first place, a part of the reason, was that they were going for their IPO at the time. And that probably was a concern that, if they didn't take that action, perhaps it would have just halted everything. Why take that risk? So now they're in a different position. They've already got their IPO, and now maybe they feel like they can, be a little bit more strong-willed. And perhaps now they've finally come around and to the realization that they're crypto's under full assault. So you can try and appease these disgusting regulators at the SEC, and just delist XRP if you think that that's gonna get them off your back. You can do that, but now at this point, years have passed, and you can see it's not going to get them off your back. That's just, you're not going to appease them. They want everything. They're taking a hammer to the entire industry. That's what they're doing. So the fact that now Coinbase is fighting back, I get that, and then you just kind of wonder, like, to what degree. So from a legal perspective, yes, we'd like to two things. We'd like to see XRP relisted on Coinbase. Of course we would. From a legal perspective, does that introduce risk? That's the question that I'm wondering. What does it say about your judgment that you're now waffling yet again on whether or not to relist XRP, and especially at a particular moment in time when that that the case is about over? We're going to get some sort of clarity in very short order. So now that they've messed up to this degree, and they've just operated in their own self-interest in terms of what they did to ensure that the IPO would go through. Now they've done that. They're in this position where you do have these inconsistencies where these other coins that are getting attacked, Coinbase is not delisting. And so I get the frustration, but I think I can kind of see what they're doing, right? I can't be the only one that thinks that, right? But also, and this is the part that I found to be super interesting. This is my favorite thing I've been looking forward to reporting on in this video, which I cited at the beginning. I'm going to explain more about it. But XRP community member named Sherry tweeted out, important takes from Coinbase response to the SEC's complaint. Crypto assets identified as computer code. Fun fact. Did you know that computer code is legally protected by the First Amendment, referring to free speech? And I'm willing to bet some of you knew that, but I don't think this is something that's broadly known. I'd never heard this exact argument before. And so I was like, well, that's interesting. So I wanted to fact check this, and I went to multiple sources, and this absolutely is true. There is a real court case that occurred almost 30 years ago that led to this being the case. And we know that cryptocurrencies are alphanumeric code, aka computer code. That's protected speech for First Amendment speech in the United States. Now, if you're in the States, you know why that's a big deal. And if you're outside, hopefully you've heard about us and our free speech. It's a gigantic deal. It's an absolutely gigantic deal. And so I just, in Googling through this, one of the things that actually came up was this old article from September of last year from You Today. And they highlighted a tweet from Attorney John Deaton. And this isn't the only time that he said it, but it just popped up, so I thought I'd just point it out. And Attorney Deaton's right here. Part of what he said in this tweet that's on your screen is that ETH, like XRP, is alphanumeric code. It's just computer code. So check this out. And this is just one of the sources that I went to. They're called Marketplace. Hadn't heard of them before, but I went to multiple places to verify the validity of this assertion. And it's a gigantic deal. And I'd love to spread this message more. So check this out. Why the First Amendment also protects code, which again XRP is the XRP ledger. It's code. It's computer code. This piece reads as follows. The First Amendment serves as a check on government intervention into our public expression through, for example, spoken or visually signed speech, writing, protesting, and coding languages like JavaScript, HTML, Python, and Perl. Computer code as free speech is a relatively new legal concept, but has a complicated history. Marketplace's Kimberly Adams spoke with technology lawyer Kendra Albert, a clinical instructor at Harvard Law School's Cyber Law Clinic, about the history of code as protected expression. Okay, so if you look in terms of like the span of the existence of our country, okay, you could say that this is a newer legal concept, but it's still almost 30 years old. We're talking about going back to 1995. So here is what Harvard attorney Kendra Albert had to say. Check this out. And again, this absolutely, specifically, as cited here, does apply to computer code cryptography specifically. The seminal case on this is the 1995 case involving a cryptographer named Daniel Bernstein, who sued the United States government for restrictions called export controls on encryption. And at the time, the United States made it illegal to export cryptography. And it was regulated actually as a munition, like a weapon. And what he said was that the United States government was making it impossible for him to share his academic work on cryptography with colleagues in other countries. So let's pause to think right here. Had this, what ultimately developed, not occurred in the 90s, we wouldn't even be able to have cryptocurrencies, like even to the point that, the fledgling crypto industry, and even think back to like 2009, we could, I mean, my gosh, it would have been shut down immediately. If this were something, because again, they were treating it as a munition, a weapon. You think you think a single exchange would have been able to get away with for more than 5 seconds hosting such a thing if it's viewed as an actual weapon? So the fact that this occurred, it cleared the way for cryptocurrencies to be able to exist, and they are just computer code. And then Kendra Albert also said the district court and the Ninth Circuit both agreed that there was expressive, important, First Amendment value in the speech that he wanted to get out there in the world, and his scientific ideas and the code that sort of proved that he could do what he said he wanted to do. Well, that's interesting, isn't it? So spread the word on that one. So like if it comes, even if you get a bad ruling, what do you think's ultimately going to happen if this goes all the way to the Supreme Court? If that's what it takes, so be it. And I hope it doesn't take that. But if it does, so be it. It's another thing here. Then there's also this. Yes, freaking SEC. Look at what they're doing. So Attorney James Murphy shared an update the other day, which ultimately led to a couple other attorneys within our community kind of chiming in here and what's going on, talking about the strategy of what's happening here. But I want to highlight just how repulsive and disgusting it is what's happening here. So here you go from Attorney James Murphy, who goes by the name Meta Law Man on Twitter. He wrote the following: SEC v. Bittrex US litigation update. Earlier today, Bittrex US, the US exchange, Bittrex Global, and William Shahara, the Bittrex founder, filed motions to dismiss the SEC's complaint. This is good news for anyone concerned about the SEC's regulatory overreach. Here's why. Bittrex has wound down its U.S. operations and put its U.S.-based exchange into bankruptcy. So, in these circumstances, Bittrex could have easily just caved to the SEC and agreed to a quick settlement, which the SEC would have paraded around as another win. But they didn't. Instead, Bittrex hired 2 high-powered law firms, and then he tagged them right there to fight back. The motions to dismiss argue, number 1, crypto assets trading on secondary markets are not securities. Number 2, the SEC lacks authority in this area under the major questions doctrine. And so I'll pause note, and this is something I talked about more in depth in a recent video, so I won't go too in depth here, but just understand that it has to do, and there's legal precedent for this now, especially due to a recent case. But anytime there's something that would have some sort of major impact on, for instance, the United States economy, if a decision by a government agency would have a major impact, if there's something along those lines, then the government agency in question that would impact, say it's the economy on such a major level, would have to cite where they have congressional authority to do the things that they're doing. Because if it's a major question, they should do so. I mean, if there's a question mark of do they even have the authority? Well, that's what the major questions doctrine is. And it's very clear that the SEC is engaging in tremendous overreach here. It's just another reason that ultimately, if you let enough time pass, things are not going to go well for the SEC, actually. I feel pretty strongly about that. Number 3, the SEC has failed to provide fair notice of its claims in violation of due process. The arguments are all expertly articulated. But why is the SEC suing Bittrex at all for failing to register as a securities exchange after it has already exited the U.S. market? One reason Bittrex may have decided to exit the U.S. market could be that the SEC subjected the company to a 6-year-long investigation. After 6 years of investigating, the SEC's complaint does not allege any fraud or customer harm at Bittrex. Inspector Javert would be proud. I have just one question. Why are our tax dollars being spent on this case? Maybe some congressional oversight is in order. Spot on, obviously, and it is a bit peculiar, is it not? And so then, yesterday, that was retweeted. That thread from Attorney Murphy was retweeted by Attorney Murphy, and he had an additional thing to say. He wrote, "Hard to understand why SEC leadership would choose to invest its resources in a failure to register case against a crypto exchange when there is A, no allegation of investor harm, and B, the exchange has exited the United States. How does this advance the investor protection mission?" And this is where you have Attorney Mark Fagel jump in. And Attorney Fagel used to work at the SEC, and he tends to defend them. Not always, but he tends to. And he responded, he thinks that this makes sense, and I do not find his argument to be compelling, but here's what he said. "The whole point of the registration requirements for both exchanges and issuers is to proactively mitigate the risk of fraud and harm. If the SEC waits until there is fraud, it's often too late to help investors. And then everyone yells at the SEC for not doing something sooner." Okay, fair enough to bring up that point, but they've already exited the United States. What is being done here? And that is not clear. He doesn't seem to have an argument for that. If you're just talking about, taking a proactive approach, and if it were the case that Bittrex were still here, it would be a lot easier to argue that. Although still, it's kind of strange after a six-year investigation, and you can't find any dirt. What in the ever-loving hell are you even doing? It's obviously an attack on crypto. It's nonsense. And so Attorney James Murphy responded to Attorney Fagel and wrote the following. "Thanks for your reply. The SEC conducted a 6-year investigation into Bittrex that apparently turned up no fraud, which is amazing considering it is a crypto exchange. To me, this is an odd case to spend the SEC's limited enforcement resources on, but I appreciate your perspective." Yeah, and I think that Attorney Murphy's making a better point there. So when Attorney Fagel here says if the SEC waits until there is fraud, well, then that's a problem. But how could there be fraud when they're no longer operating? You already did a 6-year investigation, there's no fraud, and there can't be fraud because they don't operate in the United States. Explain that. Attorney John Deaton retweeted that from Attorney Murphy, and he said, "The agenda is to file many cases in multiple jurisdictions across the U.S. so that they maximize their chances of securing court victories. So if it loses Ripple, it can point to Library or Dragon Chain or others. Max destruction." Yep, that sounds about right to me. Then Attorney Morgan retweeted that from Attorney Deaton, and he said, "The crypto industry, if it had a united strategy, could engage in lawfare and against the SEC and commence multiple actions like Coinbase did, or file multiple amicus briefs in SEC lawsuits and exhaust its resources. The entities with tokens the SEC calls securities could intervene in the SEC cases against the exchanges. That alone would be dozens of motions." Yeah, and so that's why, I've always been a proponent for, having a cohesive, world of crypto rather than all this nonsense tribalism, and just go after it. You got to go on the offense from a legal perspective when it comes to this stuff. You got to go on the offense. Then there's also this from the Wolf of All Streets, who is an individual very well known in crypto at this point, 904,000 followers on Twitter. He tweeted out, "If we don't fight back, it's possible that Americans will be left with only Bitcoin, ETH, Litecoin, and Bitcoin Cash to trade, and on exchanges solely run by Wall Street." And by the way, that's a totally legitimate concern. That was retweeted by Attorney Murphy, who said, "Speaking of fighting back, Coinbase has accelerated the timeline in its case by filing an early answer to the SEC complaint. So if you are considering joining John Deaton's class of Coinbase account holders, you should sign up now. The form is pinned on John's Twitter page." And so John Deaton is doing the same thing basically that he did in the SEC v. Ripple case, just taking that same approach. And he does have, to this point, a lot of people signed up already. And so he wrote the following on this, because he actually retweeted the following from Attorney Murphy, and Deaton said the following. "We have over 2,000 people who do not want the SEC to stand up in court and pretend to protect us. We also don't want Coinbase speaking on our behalf either. Like Ripple, if the SEC only alleged Coinbase violated the law, we would remain silent. But the SEC is making claims unsupported by existing law and in violation of one's freedom to engage in global trade and finance. In sum, we're sick and tired of the SEC's form of protection. Had Gary Gensler investigated SB fraud instead of meeting with him multiple times, negotiating a deal that would have benefited the Bernie Madoff of crypto, maybe we would think differently. And for those of you that say I'm speculating with no proof that was what was happening, then Gary should release all the notes, the emails, and correspondence between the SEC and FTX/SBF. Prove that I'm just a cynical conspiracy theorist who suffers from confirmation bias. Prove it. In fact, if proven that I'm full of bleep regarding my speculation, I'll highlight all the notes, emails, etc. on crypto law and publicly admit how wrong I was. Yeah, well, that's because Attorney Deaton's intellectually honest here, but come on, he's right. Like, come on. There's enough already publicly known that makes it like a virtual certainty that this is indeed the case. And so anyway, I love what Attorney Deaton is doing. He's pushing back again. Same type of thing he's doing in the SEC v. Ripple case. And now still, in this case now, thousands of people represented. That is cool as hell. So again, look, there's lots of reason to be truly optimistic. It's just perhaps the case that it could, if we don't get a lower court ruling that is reasonable, may have to buckle up for the long haul. That is possible. But I still, at this particular juncture in time, am very optimistic. But I think it's reasonable to be very optimistic at this moment in terms of clarity for transactions, XRP, in the secondary markets. And look, I understand the arguments, and a lot of attorneys think Judge Torres is not likely to acknowledge secondary market transactions, which is what we really need here in the United States to have that's proper level of clarity. But I think Attorney Deaton has a very compelling point with the embodiment theory that it's become known as, this tremendous overreach claiming that even secondary market transactions, literally the SEC argues secondary market transactions represent Ripple's efforts. Well, okay, so it's true that the judge isn't being asked to rule on secondary markets, and so typically judges will take a minimalist approach. So you would think, yeah, well, take the minimalist approach, Judge Torres, that's what she's going to do, and she's not going to talk about secondary markets. But by going with this novel theory of the embodiment theory and bringing up secondary markets, it looks to me, and fine, I get it, I don't have any sort of legal background, but it looks to me like the judge has to respond at this point, because the SEC argued specifically about secondary markets. It's not like the judge would just be bringing up secondary markets out of nowhere for the hell of it. She'd be bringing it up because the SEC brought it up. And yes, fine, there's a, amicus counsel, also, how many briefs were filed, right? And so secondary market transactions brought up again and again and again, sure. And maybe she could respond to it just for that reason, but the most solid reason that she should respond and should feel obligated to respond is because the SEC brought it up in support of their arguments. So I'm optimistic she's going to, but maybe not. We'll see. But even if it doesn't come up there, get to the remedy, because you know what's going to happen. You get to the remedies portion, then John Deaton's just going to bring it up again. And even in the library case, in the remedies portion, that judge even has acknowledged, yeah, that's not part of my ruling. So there's a lot of ways that this can unfold here, but I think it's very clear that if you're an XRP holder, if you're just a crypto holder, case precedent, legal precedent, the law, it's all on our side. We just have to be patient and let this stuff play out. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.